So my name is Dr. Megan Bowman from the Law School at King's College London. It's my absolute pleasure to be here. I think this is my first in-person conference since 2019, so this is exciting. And I particularly want to thank the conference organisers for I think what must be a huge endeavour here with the hybrid nature of it, as well as the important subject matter. So particularly Montserrat and Sonam and Kat, and also Professors Lee and Vaughan and Scotford. Thank you, Richard. And particularly to Eloise, thank you. I know you would have put in so much effort to this, and to not be here would be really hard. Our hearts are with you in Australia. Okay, so let me introduce our speakers. So let me introduce the topic, which is climate change and business and the rule of law. And particularly we'll be looking at this topic, which I think is one of the most exciting topics, maybe in the wake of the salutary sentiments of some of our speakers in the preceding panel on climate litigation. We might be able to pick up a little bit of optimism in this panel, in this session. I hope so. Let's see how it unfolds. Because certainly, as has been phrased in the program, this notion of business regulation is seen both as the problem and the solution. So it's a really exciting area, and I guess for the rule of law, it's that sense of how does the legal system and power fit together in this corporate private sector milieu. So our speakers, we have three incredible speakers. Next to me, to my left at an appropriately civil distance, is Richard Harvey, legal counsel at Greenpeace International. We will also have online Dan Leader, partner and barrister at the International Department at Lee Day, the law firm. And also, given that this conference really is showcasing an embarrassment of Antipodean riches, we have Professor Christine Parker, who's also online, who is a professor and associate dean of research at Melbourne Law School. So welcome to all our speakers. The way this session is going to run is I'm going to be super duper strict on timing for our speakers. So you will have 15 minutes and not 1 second more. And then I hope that we will have 10 minutes time for question and answer. We will be running 15 minutes over for this session, given the later start. All right then, I think it's time to take off, Richard. What do you reckon?
Let's go.
Let's go to Richard Harvey.
I start by acknowledging my white, male, class and social privilege. We urgently need a decolonised, intersectional approach to the rule of law. Unless we're learning from Indigenous peoples' profound understanding of humanity's place in the natural world, we will fail, and the rule of law will mean less and less as the climate crisis grows and grows. 37 days ago, the fossil fuel industry's contribution to the climate crisis took on a new dimension: war profiteering. Some say this is nothing new. Since Putin invaded Ukraine, which has been an elephant wandering around the back of this room for the last 24 hours plus, the EU has paid him more than 22 billion euros. That's over 6 billion a day for his fossil fuels. Rising fuel prices mean windfall profits for Shell, BP, ExxonMobil, Total and the rest. They may even exceed their super profits of 2021. And BP spokesperson says, generally, a windfall tax on UK oil and gas producers would not encourage investment in producing the UK's gas resources. It wouldn't encourage investment in renewables, it wouldn't encourage investment in fossil gas. I know it's April Fool's Day, but can they hear themselves? The American petroleum industry tells the Biden administration this is the time to ensure long-term American energy leadership and security. In 2019, the EU imported 41% of its gas from Russia. Last year, it was around 45%. And 36% of Russia's state budget comes from its oil and gas sales. The US became the world's largest LNG exporter last year, and today their LNG supertankers are heading for Europe to wean us off Russian dependence and cement our dependence on American fossil fuels. Are any political leaders talking seriously about weaning us off fossil fuel dependence altogether? Norway stands to rack up almost 170 billion additional US dollars in oil and gas revenue this year. 170 billion. Their European Climate Pact ambassador is a little embarrassed. He says, the most important thing is to show solidarity, to display leadership at a historic moment. My kids are going to ask me, Dad, what did Norway do in the Ukraine war? I don't want to tell them that we made a killing. That sends chills down my spine. In the absence of a rights-based approach from political leadership, Greenpeace, Client Earth, Friends of the Earth and others are turning to the courts for guidance. And speaking of Norway, my first case is the people against Arctic oil. Greenpeace Nordic and Nature and Youth versus Norway's Ministry of Petroleum and Energy began their legal fight in 2016 against the Norwegian government's decision to license new drilling in the fragile Arctic. They used the previously untested right to a healthy environment for present and future generations in Article 112 of Norway's constitution, as well as Articles 2 and 8 of the European Convention. You may say, well, surely that's a case against a government. Your brief is to talk about corporations. Fair enough, but when the government you're challenging owns 67% of the corporation licensed to drill for Arctic oil and gas that we can never afford to burn, then you have state capture by another name. Those working on the original draft of the case wondered whether the petroleum industry would seek to come in as interveners, potentially increasing exposure to costs and lengthening the legislation. But in fact, the fossil fuel companies knew they could rely on the government attorney to protect their interests. Norway exports 95% of its fossil fuels. It doesn't need them at home. And the Supreme Court ruled against the government in holding that environmental impact assessments must include all emissions, including Scope 3 emissions from combusted exports. However, the majority, 11-4, held that the government could defer making those assessments until after the fossil companies completed their exploration and applied for extraction licenses. So it suggested they were going to spend a whole bunch of money trying to find new oil and gas reserves and then apply for licenses and be told, oh no, we're not going to let you dig them out of the ground. Well, of course, that's preposterous. That's not the order in which it should be done, as 4 of the judges fully understood. So together with 6 young climate activists, Greenpeace Nordic and Nature and Youth are taking their fight to the European Court of Human Rights, arguing that Norway's licensing decision violates the right to life, the right to the enjoyment of family life, and in addition, it discriminates unlawfully against the indigenous Sami population's culture, land and resources, as well as against the youth whose generation will bear the unequal burden of climate change impacts. The court communicated their application to the Norwegian government in December 2021. This case is the first to ask the European Court to address the effects of fossil fuel extraction on the climate crisis. The Norwegian government's response is due in 13 days' time. We arrive in Strasbourg together with the other climate vulnerability cases presented by the Swiss senior climate women and the Portuguese youth. We believe the time is now for a clear signal from the European Court to judges in Europe and beyond to clarify the human rights obligations of states and corporations in the context of climate change. Crossing to the other side of the world, the Philippines Commission of Human Rights. In November 2013, the Philippines was ravaged by one of the most powerful tropical cyclones ever recorded. Typhoon Haiyan claimed the lives of thousands and affected millions of others. Coincidentally, in 2013, Richard Heady's Climate Accountability Institute published its peer-reviewed findings on the carbon majors' responsibilities for anthropogenic greenhouse gas emissions in the industrial age. These findings identified 47 investor-owned fossil fuel producers, ExxonMobil, Shell, BP, Chevron, Total, etc., as contributing to extreme weather events such as Typhoon Haiyan. Armed with this evidence, grassroots organizations petitioned the Philippines Commission on Human Rights to investigate the role of the carbon majors in contributing to climate change-related human rights violations. The Commission conducted fact-finding missions around the Philippines, held hearings and consultations convenient for the carbon majors' headquarters in the US, in the UK, and in the Netherlands. And they established a climate change observatory as a public resource for Filipinos to assess the impact of their government's compliance with international treaty obligations to protect the environment. The Commission's findings have sadly not yet been made public. However, its leading commissioner announced their preliminary finding that the carbon majors may be held morally and legally liable for climate change. This commission represents the first time a human rights body has asserted its authority to investigate multinational fossil fuel companies. We believe this will result in one of the world's first legal findings of corporate responsibility for climate change and will likely trigger other investigations and judicial actions in the Philippines and elsewhere. Last year, the French carbon major Total announced it was reinventing itself as Total Energies or Total Énergie. Total invention would have been a more honest description. In March 2022, Greenpeace France, Les Amis de la Terre and Notre Affaire à Tout, supported by Client Earth, took Total Energies to court in Paris to protect the public from its misleading environmental claims on the alleged virtues of fossil gas and biofuels, which the claimants say promote false net zero claims to consumers and violate the EU's Unfair Marketing Practices Directive. Total Energies shamelessly tells consumers fossil gas is comparable to renewables, and they are careful not to explain that their renewable investments in biofuels actually come mainly from forest-destroying palm oil and soya. The evidence will show that the environmental impacts of producing biodiesel release on average 80% more greenhouse gases than the diesel it replaces. And these natural fossil gas, their natural fossil gas is 85 to 90% methane, each ton of which released into the atmosphere creates a greenhouse effect 84 times greater than a ton of CO2. The claim asks the court to rule that the advertisements are misleading, that they violate consumer law, and to order Total to stop misleading advertising and publicize the court's ruling on its websites, in social media and on the TV, and to ban Total from making net zero claims unless it can include prominent information on fossil fuels' roles in causing climate change, and that they can publish verifiable plans aligned with a net zero pathway. And as we heard yesterday, Client Earth has now taken the next logical step in relation to Shell by serving notice on 13 directors that they face personal liability for mismanaging the climate risk facing the company. As Greenpeace International's Climate Justice Counsel Louise Fournier says, companies and their directors are at risk if they claim they have a specific climate-related strategy, but in fact are not acting in line with what the science requires. Turning now to the European Citizens Initiative, which was launched last October by Greenpeace and more than 20 other NGOs. The industry has been promoting fossil gas as a bridge fuel on the road to a sustainable future. Putin has burned that bridge. The fossil fuel industry fuels the climate crisis, it fuels war and conflict around the world while buying social acceptance by pouring money into advertising and sponsoring sports, cultural and educational institutions. Just as tobacco advertising was legally banned in the EU as a threat to our health, it's now time to call out the fossil fuel industry too. The objective? 1 million signatures across the European Union to ban all advertising and sponsorship by companies selling fossil goods and services. Where there's a will, ways will be found. Governments have talked for years about a managed transition away from fossil fuels. They've done nothing. Suddenly, overnight, they have discovered that they can manage without Russian fuel. The industry knows a managed transition can be done. We know it must be done. But paraphrasing St. Augustine, the carbon majors say, "Oh Lord, please don't make us do it just yet." In conclusion, if Putin can shred the rule of law playbook and violate the rules of war, what does this say to the rising generation? On Tuesday this week, I attended the NYU Centre for Human Rights and Global Justice webinar entitled Youth in Focus, Youth Activism's Role in Pushing Climate Action Forward. 19-year-old Chilean-Mexican Chie Bastida of the indigenous Otomi Toltec Nation spoke in calm and measured tones about the Glasgow COP and all those COPs before it. She said, "These COPs are older than all of us. They're just a PR exercise. They have the power, they have the money. If they intended to do anything, they would have done it by now. They've done nothing. We can't wait for them. My hope comes from my community."
Thank you so much, Richard. Very passionate words, very rousing. I had lots of chills during that, so thank you. Dan, are you with us? Welcome, Dan. Good to see and hear you. So please, the floor is yours, 15 minutes.
Thank you very much. Well, it's a huge pleasure to be asked to speak to you today on this hugely important topic. I've been asked to outline current developments in business and human rights case law and litigation and explain the potential impact this will have on climate change litigation. In the short time I have, I want to briefly focus on 3 points. Firstly, I want to outline the fast developing jurisprudence on corporate accountability around the world, and particularly in the UK. Secondly, I want to explain the concept of parent company liability and outline where we are in light of 2 recent decisions from the UK Supreme Court. And thirdly, I want to unpack the potential relevance of this case law on climate change litigation. So the problem of corporate impunity in many parts of the globe is fundamentally, in my submission, a rule of law issue. The reality is that in many countries, corporations operate with little or no regulatory oversight, safe in the knowledge that victims of corporate abuse will never be able to seek redress locally in their courts for a myriad of complex reasons. To combat this, in part, in recent years, lawyers from the global north and the global south and activists have sought to hold parent companies in the global north to account for the sins of their subsidiaries. And it's fair to say that the rise of international human rights and environmental litigation against multinational companies is now a global phenomenon. The world of corporate accountability has radically changed from where we were when I first started 20 years ago. And just in the last few years, there have been hugely significant developments in multiple jurisdictions. To give just a handful of examples, in 2020, in the case of Nevson, which concerned human rights abuses in Eritrea, in a landmark judgment, the Canadian Supreme Court ruled that corporations can be liable for breaches of customary international law. Last year, the Dutch Court of Appeal ruled against Shell's parent company in favor of 2 Nigerian communities impacted by oil pollution, and ordered Royal Dutch Shell to change its practices, which was the culmination of 13 years of civil litigation. Again, a totally landmark judgment. This year, the French Cour de Cassation ruled that the French company Lafarge could be indicted for complicity in war crimes in Syria. And here in the UK, in the last 3 years, there have now been 2 unanimous Supreme Court judgments which have ruled in favor of African communities who are seeking civil remedies against 2 multinational companies following large-scale environmental disasters. In tandem with this, we are seeing countries in Europe, within the European Union, put in place mandatory human rights due diligence laws, which for the first time place legal obligations on parent companies to ensure their subsidiaries and supply chains are free of human rights and environmental abuses. Whilst the UK is lagging behind in terms of a human rights due diligence legal framework, the common law case law, which has been developed over recent years, has created one of the most progressive legal regimes in the world. And that case law is having ripple effects in other jurisdictions, particularly in other common law countries. Importantly, there is now a growing community of lawyers around the world who are bringing these cases in collaboration with activists from the Global South and the Global North. And this allows victims of corporate abuses of all kinds to seek remedies against multinationals in circumstances where it was simply impossible to do so due to access to justice limitations in their countries. In my submission, the direction of travel is set for many more human rights and environmental cases in the future in multiple jurisdictions around the world. So secondly, let me move on to parent company liability. To bring these civil cases against multinational companies, lawyers generally use this principle, which has been developed over the past 25 years in a number of cases, and which is now an established part of English jurisprudence. To be clear, parent company liability is emphatically not to be confused with piercing the corporate veil. Rather, it seeks to hold parent companies to account for their own failures in supervising, advising, or managing their own subsidiaries. To illustrate the point by way of an example, in an environmental case, if a parent company exercises de facto control or supervision over a subsidiary, or issues flawed advice and guidance to that subsidiary on, say, oil spill cleanup, which causes loss and damage to indigenous communities, that can give rise to a separate and distinct legal duty of care, concurrent with the duty of care which would be placed on the subsidiary, which is the direct tortfeasor. You can sue a parent company, much as a claimant can sue a contractor who provided negligent advice or services. So the case law, as I've said, is now extensive, culminating in 2 unanimous Supreme Court judgments in recent years. The first is Vedanta, which concerned pollution of communities surrounding a Zambian copper mine. And secondly, Okapabi and Shell, which concerns 2 communities who have sued Royal Dutch Shell again for widespread pollution caused by spills from their pipelines. Pollution that's lasted for decades. Previously, the Court of Appeal had expressed the view that liability could only arise in these circumstances if there was clear evidence of operational control of the subsidiary by the parent company. A very difficult evidential hurdle for claimants to prove prior to disclosure. This onerous test was flatly rejected by the Supreme Court, which has now significantly broadened the potential scope of parent company liability. It's made clear that multinationals could be liable in numerous ways which fall short of operational control. By way of example, the Supreme Court set out 4 potential non-exhaustive routes to liability. It's become known in the lexicon as the Vedanta 4 routes. Firstly, a parent company can be liable if it takes over the management or joint management of a subsidiary. Could be liable, secondly, if it issues defective advice or guidance to a subsidiary. Thirdly, very importantly for our purposes, a company could be liable if it promulgates defective group-wide policies. And fourthly, and perhaps most excitingly, the Supreme Court has now said twice that a parent company which publicly commits to a course of action, for example, in exercising particular degree of control or supervision of a subsidiary, but fails to honor those commitments, could also potentially be liable under parent company principles. This has hugely significant implications for multinational companies, who almost without exception have policy frameworks and make extensive public ESG commitments, but who now are increasingly facing the prospect of litigation risk if they turn a blind eye to human rights and environmental abuses in their group or within their supply chain. It opens the door to a much more ambitious set of potential human rights and environmental cases than activists and lawyers ever previously thought possible. But what, I hear you say, has any of this very noble achievement got anything to do with climate change? Well, I would simply make 3 points in the short time I have. Firstly, this case law opens the door to communities in the global south who have suffered environmental harms caused by the activities of high-emitting companies to seek redress for the first time against the parent companies in the jurisdictions where those parent companies are domiciled. On its own, that is something of a legal revolution, and indeed should hopefully have a deterrent effect on the conduct of multinational companies over time, which will contribute to the fight against climate change. Secondly, specifically on climate change, if hypothetically a subsidiary of a large, high-emitting multinational company is not complying with local climate change laws on, say, emissions, the laws in many global south countries are in fact extremely progressive, more progressive than the laws in the global north, then the parent company could be sued in the country of their domicile for failing to ensure that compliance. So to give you an example, the Ugandan National Climate Change Act 2021 allows for legal sanction against companies whose, quote, action or omission threatens effort toward adaptation or mitigation of climate change. The breach of that act by a Ugandan subsidiary of a hypothetical UK multinational could be litigated in London against that parent company. In circumstances, clearly that would only be desirable to do that if there was no prospect of being able to litigate that case in Uganda. But sadly, that's often the case. And thirdly, this, if a parent company makes commitments about climate change and its own emissions, but fails to honor those commitments, the Supreme Court jurisprudence opens the door to potential litigation to hold them to account under the so-called Vedanta Route 4. So again, for example, if an oil major commits to reduce emissions by 40% by 2030 and fails to honor those commitments, that could potentially be subject to litigation on the basis of Vedanta principles. So in conclusion, it's clear that multinationals are under increased scrutiny and the legal tools for holding them to account are fast developing. They increasingly face serious litigation risk, which can be costly and cause significant reputational damage. This is an exciting and fast developing area of law, and one which I predict will lead to many more cases around the world in the years to come, including many cases which concern corporations and climate change. Thank you very much.
Fantastic. Excuse me. Thank you so much, Dan. Really exciting. See, I told you we might get some optimism in this session, and perhaps we are. So that's just such a wonderful, succinct, clear summary of the potential in this area. Thank you, Dan. Christine, welcome, and over to you.
Okay. As is our custom in Australia, I wish to start my remarks by acknowledging the country on which I live and work. I'm speaking to you from Melbourne, Naarm, the unceded land of the Wurundjeri people. First Nations care of this country endured for tens of thousands of years as seas rose and fell and climates changed, and it continues to this day. I pay my respects to Aboriginal and Torres Strait Islanders past and present, and also extend my respect to any other First Nations people present at this session today. My talk is based on work that I'm doing with Fiona Haynes, outlining the challenge of ecological regulation, taming capitalism to ensure businesses operate within and contribute to flourishing eco-social systems rather than extracting and exploiting from them. My thesis is that traditional instrumental conceptions of business regulation, constrained by formal rule of law considerations, are too narrow to address the multiple intersecting eco-social crises we now face. Newer, more responsive theories of regulation are promising, however, too often fall victim to the very market mantras that we need to challenge. And I'm going to finish my talk by proposing some directions for rethinking the purpose of law in ecological regulation. But first, I'll start with a brief outline of what we see as the challenge. Australian philosopher Professor Danielle Sellermajor uses the term omnicide for the vastness of killing involved in climate-induced catastrophes, such as Australia's black summer of bushfires that we endured just before the COVID pandemic. It's a dramatic term, but apt for the existential threat we Earthlings will face over the coming years and decades. The planetary boundaries model shown on this slide emphasises that changes in any one ecological process will likely trigger further global environmental change in the others, creating destabilising feedbacks, having reverberating catastrophic effects. Thus, climate change, fertiliser overuse, species extinction, and so on, they're not discrete insular problems that could, in principle at least, be solved by individual interventions aimed at particular practices in specific places. They're intrinsically interconnected, and they're also intertwined with ongoing economic injustice and inequality. Individuals, businesses, and government are all caught up in a self-reinforcing, financialised, productivist, consumptogenic system, one that encourages the production and consumption of commodities in greater amounts, more quickly, more often, and seen as the only way of flourishing in our society. This whole system of business finance, production, advertising, consumption operates to create and perpetuate an extractive, destructive system, and one in which those who have benefited the most will be the first who are able to afford protection from the ravages of climate change and the other disasters, while those who have benefited the least are already the first to suffer the burdens, as we know. Law, and especially business regulation, and by that I mean things like worker health and safety rules, environmental regulation, consumer protection law, and so on, purport to address these problems. Yet law is duplicitous in this regard. Business regulation is always animated by two contradictory impulses. On the one hand, to protect capitalist investment, and at the same time to reassure us that its worst excesses are being controlled. Law created capitalism. It created private property. It created the corporate form with its limited liability, created intellectual property, tax loopholes, and so on, all the things that support the consumptogenic system. Yet there are also constant counter movements seeking to mobilise law and regulation to tame capitalism, as we've been talking about, to limit the capacity of commercial activity to extract further economic value from humans and from ecological systems. So business regulation we see as a constant contest, a series of tussles between different actors as in whose interests law will operate, which values will be represented. And rule of law ideas are used on both or all sides of that struggle. The dominant liberal worldview understands business impact on the social and natural worlds as a series of individual externalities, requiring rules to fix market failures one issue at a time through instrumental regulation designed to intrude as discreetly and narrowly as possible into commercial activity. This approach is perfectly illustrated by the famous or infamous quote from Milton Friedman on the slide. Government interference with business should be strictly limited on this view in line with the traditional conception of the rule of law that emphasises the protection of the individual, and businesses included, against the power of government. Now, I don't want to underestimate the important improvements in fairness and safety that have been achieved by instrumental regulation. Airplanes, drinking water, even coal mines are a lot safer than they used to be. And I'm certainly not calling for instrumental regulation to be done away with. But the limitations in what it can achieve, given the enormity, complexity, and interconnectedness of the eco-social crisis we face, are manifold. It attempts to achieve the impossible, a series of individual rules and regulatory agencies, each subjected to the strictest scrutiny of the rule of law and each in tension with one another, are simply not able to tame the whole consumptogenic mess we're currently living with. The alternative, responsive regulation conception, pushes companies to go beyond mere compliance in line with triple bottom line or environmental social governance type ambitions. In their influential book, which is shown on the slide, Ian Ayres and John Braithwaite proposed that regulators should seek to actively nurture the civic responsibility of business via a judicious use of persuasion with a credible threat of enforcement in the background when persuasion fails. They showed that businesses and individuals can be motivated to do the right thing beyond the strictest rule of law standards by social influence and appeals to virtue alongside threats of sanctions. They also proposed that rule of law accountability requires the involvement of non-state public interest groups, NGOs, to hold both state and business accountable. Other theorists, like Neil Gunningham, see businesses as regulated by social and economic licenses alongside the legal license enshrined in official regulatory regimes. And much regulatory studies scholarship has shown how these legal, social, and economic licenses can be activated by a multiplicity of plural actors, including supply chain partners, financial investors, accreditation agencies, public interest groups, and social movements, and also, of course, official legal regulators. These ideas draw on a much thicker, richer conception of the rule of law, in which democratic participation in law and regulation is required to hold both government and corporations accountable. It also reflects a more plural conception of what counts as law, not just official law, but industry self-regulation, community action, even restorative justice processes that might incorporate Indigenous knowledges. So something like the fossil fuel divestment campaign, which was commenced by Bill McKibben's 350.org, taken up by social movements, underlined in public interest litigation, and eventually taken on by leading financial actors and financial regulators, is arguably a good example of responsive regulation in action that changed the whole baseline of how we think about investment in fossil fuels. But the limitation, and it is significant, is that the radical aspirations of campaigns like the divestment campaign are often defeated by countervailing pressure from business to make any broader obligations not only voluntary, but also consistent with a dominant focus on pursuing profit. We're seeing this now with the greenwashing of even the very limited requirements of corporate disclosures on climate change playing out. It is still the case, as Naomi Klein lamented, that generally only markets are seen as legitimate constraints on business, and government action to constrain businesses is defined as authoritarian and exceptional. The tussle over business regulation continues, and rule of law considerations are often utilised to constrain and blunt radical responsive regulation. Fiona and I propose 3 radical step changes for business regulation that we call ecological regulation. First, a radically different purpose for regulation and indeed the rule of law. The fundamental purpose should surely be to enable and ensure human flourishing in relation with each other and with other living beings and ecological systems. This entails recognising social and ecological actors, that is, other living species, beings and ecosystems in our governance systems, and recognising that we humans are not just economic and political actors, but embodied social ecological beings who depend on each other and the living world for life. First Nations laws and knowledges have long recognised this. Second, monocultures. Monocultures are anathema to living ecosystems which require diversity for flourishing. Yet our global political economy concentrates power in a monoculture of large corporate and financial actors. And this is frequently enabled by law. Regulation needs to operate to revalue diversity of economic, social, political, and ecological activity. It needs to support the core or caring economy, the gift economy, volunteer and activist work, and radically different ways of doing business, radical social and environmental entrepreneurialism. Third, accountability. One of the most intractable problems is how to ensure large for-profit businesses are held to account, yes, for compliance with instrumental rules, and also for respecting planetary boundaries and social and ecological justice. By accountability, we mean a public and accessible reasoned justification by businesses of their commitment to and compatibility with ecological flourishing. Accountability should be premised on a substantive change in behaviour, not just punishment for single instances of bad behaviour, which still allow damaging systems to remain. Fiona and I have an ever-growing wish list of wide-ranging legal and regulatory reforms that we believe would generate the conditions for ecological regulation. These include a guaranteed living wage and basic income to socially support humans, ecological rights for nature, bans on government subsidies of harmful activities like fossil fuels, deforestation, monocultural agriculture, and much heavier restrictions on many forms of business advertising. We also suggest the radical separation of government and big business and a reversal of current repressive action against protest and activism. Activism against ecocide and indeed omnicide must be valued and not punished if we're to create the conditions for ecological flourishing. We see these kind of basic condition reforms as fundamental to the new ecological rule of law necessary for the long eco-social emergency that we are now facing. Thank you. That's the end of my talk, and there is a longer paper that I'm very happy to share with anyone who's interested.
Thank you so much, Christine. That's fantastic. A really exciting promise of how we can reconceptualize and reaction, I guess, completely reconsider how we enact regulation and law. Very far-reaching and very ambitious. So I'm sure that you'll get some questions on that. And on that note, I want to firstly thank all of my speakers, our speakers, the three speakers, Richard, Christine and Dan, for speaking so beautifully and for so conscientiously sticking to time. I want to close this session by thanking each of our speakers, Richard Harvey, Dan Leader and Professor Christine Parker, and for all of the engagement in the room. Thank you so much.